Our next witness is Mr. Josh Blackman. He is a professor at law at the South Texas College of Law in Houston, Texas, where he specializes in constitutional law, law and technology, and the study of the United States Supreme Court. He is the author of 59 published articles, 3 books, and numerous amicus briefs, and is the editor of a case book on constitutional law. He received his J.D. magna cum laude from George Mason University School of Law, where he served as articles editor of the George Mason Law Review. He received his B.S. magna cum laude from Penn State University, the Pennsylvania State University. He was a law clerk for the Honorable Danny J. Boggs of the U.S. Court of Appeals for the Sixth Circuit and for the Honorable Kim Gibson of the U.S. District Court for the Western District of Pennsylvania. Professor Blackman, you are recognized for 5 minutes.
Thank you. Chairman Cohen, Ranking Member Johnson, thank you for inviting me to testify. My name is Josh Blackman, and I'm a constitutional law professor at the South Texas College of Law in Houston. People often think that the courts have a monopoly on interpreting the Constitution. They don't. As we speak, the House managers are trying President Trump for violating the Constitution, and here we will discuss the constitutional means to prevent abuse of the clemency power. In my brief opening remarks, I'd like to make 3 primary points. First, I will discuss an important purpose of the pardon power. Second, I will consider proposed statutory regulations of the pardon power. And third, I will talk about H.R. 4, a proposed constitutional amendment that would limit presidential clemency. Today, people often view the pardon power as a form of error correction. For example, the courts made an error by imposing an unjust sentence, or prosecutors pursued an unjust charge. But as originally understood, clemency could serve a greater purpose. In Federalist Number 74, Alexander Hamilton identified the, quote, principal argument for the pardon power, quote, restoring the tranquility of the Commonwealth. Pardons do not merely help individuals. Presidents can issue pardons to advance broader public policies. Some of the most famous pardons in American history serve this purpose. President Washington pardoned participants in the Whiskey Rebellion. President Jefferson pardoned those convicted under the Sedition Act. After the Civil War, President Johnson pardoned former Confederates. Each of these decisions was unpopular in some quarters, but in each case, the president used his pardon power to pursue the common good as he saw it. This history brings me to my second point. Last summer, this committee marked up the Abuse of Pardon Prevention Act. I criticized this bill in a post I co-authored for Lawfare with my colleague Seth Barrett-Tillman, who was a lecturer at the Maynooth University Department of Law in Ireland, and I will submit that post for the record. In short, this proposed bill would alter the presidency such that he would now second-guess his official actions for fear of prosecution. Congress should not empower federal prosecutors through the power of the criminal process to dictate what the public interest is. Third, this committee is considering H.R. 4, a proposed constitutional amendment that would limit whom the president can pardon. I oppose this amendment. It attempts to constitutionalize a single conception of the public interest, what is and is not a proper pardon. The public interest is always contestable because no one has the institutional knowledge to declare a monopoly on what is in the common good. The president should be able to make important decisions with vigor, independence, and dispatch. The president should have the greatest latitude to issue pardons precisely because the president should have the greatest latitude to pursue what he sees as the common good. Limiting the president's power to issue pardons will limit the president's power to promote what Hamilton referred to as the tranquility of the Commonwealth. This amendment should not be adopted. Thank you for your time, and I will be happy to answer any of your questions.
I'd like to recognize the ranking member, Mr. Johnson, at this point.
Thank you, Mr. Chairman. I've got a few questions for Professor Blackman, and I just wanted to start first and clarify something. Isn't it true that the Supreme Court has long affirmed that the president's pardon power is not subject to any legislative control at all?
Absolutely. Going back almost 160 years, there's a case called Ex parte Garland, In that case, the Supreme Court held that there's basically no limitations in the pardon power. And this really hasn't been challenged by the Supreme Court. They've reaffirmed in other cases since. So I think your reading of the case law is correct, Representative.
So thank you for clarifying that. I think it's important for the full context of all this. And you've also, as you noted, you publicly opposed House Joint Resolution 4. Among other things, it would invalidate any pardon issued for a corrupt purpose. That's the quote, the language taken right out of the resolution. What's your understanding of that phrase, and why is that so problematic?
I think it's really important that we focus on the word corrupt. The chairman mentioned this word corrupt. My good friend Carolyn Frederickson mentioned the word corrupt. This is a word in which people disagree. Federal prosecutors often have a lot of difficulty proving what is a corrupt intent. You know, the classic example, I give a politician a suitcase full of cash in exchange for some public service. Okay, I'm okay with that. That's corrupt. But when we're talking about something a little bit more blurry, for example, when someone says there's some sort of unjust prosecution and he determines that in order to end this unjust prosecution, we need to issue a pardon. Under the proposed statute, that could be a thing of value, right? You're giving a thing of value to perhaps end an investigation, but that's still a public act and one which the president has. I'll be very hesitant to push the boundaries of what is and is not a bribe in a constitutional amendment or this proposed statute.
Thank you for that. House Joint Resolution 4 is not the first time, of course, that our Democrat colleagues have used legislation about pardons to target President Trump. Last Congress, Representative Adam Schiff introduced H.R. 7694, the Abuse of the Pardon Prevention Act. This committee reviewed that legislation last summer. Professor, you authored an article concluding that the bill would have criminalized politics. And can you elaborate on that a little bit, explain what the problem is there?
Sure, and I think the statute suffers from a similar problem that the amendment does. It uses this word corrupt and allows federal prosecutors to decide when the president's acting in the public interest and when he's not. Basically, corrupt is going to be the opposite of whatever the prosecutor thinks is the public interest, and I think it's dangerous. The pardon is a political act; it's a public act. I actually agree with the chairman that the secret pardons are problematic, and I'm going to go with him on that one. But to the extent that these pardons are public, the president can take the political flak for it. And if there's an abuse of power, impeachment's the remedy. James Madison said so 200 years ago. I don't think that legislation or even an amendment is the right way to ex ante in advance try to limit this authority.
Very good. This may be my last question. We're running out of time, but I was intrigued by what Professor Naftali just testified to in his premise that there are some pardons that are so egregious that it really does require amending the Constitution or some other corrective action, as he said. And he noted President Clinton, who is probably the most notorious abuser of the pardon power, at least in the modern era, for all the things he did. I wonder what your reaction is to your colleague there. And although there are some very egregious examples, does that mean now that we should change the Constitution wholesale?
I think, and I'm grateful for my friend Professor Naftali's remarks. I think the remedy should be after the fact, not before the fact. I mean, today we're seeing that they can impeach a former president. Apparently, that's the new rule. And so if a president decides to engage in sort of misconduct in the last month or two of his term, there are political remedies. But I think trying to legislate in advance is problematic because now whenever the president considers, do I issue a pardon? Do I not? He's always thinking, man, if I issue this pardon, I'm going to get in trouble. Will some federal prosecutor, the next Robert Mueller, try to indict me because they issue this pardon? That's a chilling effect I think is problematic. And I think this body, Congress, can use oversight after the fact rather than chilling beforehand.
I got 30 seconds left. Let me just ask you a mechanical question because there's a lot of confusion about it. What's the role of the Department of Justice's pardon attorney in all this, the recommendations they make?
The DOJ is purely advisory. The Attorney General and his subordinates make a recommendation, but ultimately it's the president and the president alone who decides whether to check yes or no in that pardon box.
Very good. With 7 seconds left, I'll yield back, Mr. Chairman. Thank you to all the witnesses.
Perhaps the most egregious recent example of politicized prosecutions came with the Mueller proceedings and the prosecution of Michael Flynn. Mueller's prosecutors falsified documents to the FISA court. They withheld material evidence from the court. They held interviews under false pretenses. They operated in an entirely partisan manner. where Republicans were singled out while the actions of Democrats in initiating the entire Russian collusion hoax were ignored. Just because the targets of this politicized process were associates of the president doesn't make these actions any less egregious or the injustice any less offensive or the remedy any less necessary. There were a number of pardons issued by President Trump and his predecessors that I've cringed at, and I'm sure I'll be outraged at pardons this president will make. But I think the importance of the pardon power in rendering justice in matters like the Mueller investigation argue against any limitations on it. I can't believe the founders didn't give great consideration to the frailties of human nature in assigning this power to the president. Professor Blackman, could you discuss in greater detail the reasons the founders offered in writing this provision of the Constitution as they did, and how they might reply to some of the objections we've heard today?
Thank you so much, Representative. The framers modeled the pardon power after the prerogative of the king, which was basically an almost absolute power. There are two limits, only pardons for federal offenses, and you can't pardon impeachment. Beyond that, there's really no discretion. During the Constitutional Convention, there were debates about whether the Congress should have a role in the pardon power. For example, whether the Congress must approve of a pardon, and those proposals were voted down. And I think that history tells us that the framers viewed this power should be residing in a single person, the president. I see over your shoulder George Washington, our first president. He very famously issued pardons to those who were in the Whiskey Rebellion. This was basically an uprising, insurrection, perhaps not too dissimilar to what people think happened a few weeks ago at the Capitol. Washington pardoned the people in the Whiskey Rebellion to make peace, to bring tranquility to the nation. It was controversial in some quarters, but I think it did a lot of very important work. And I think it's why one person, the president, should have discretion to decide how to pursue the common good.
Well, I'm sure they must have foreseen, just human nature being what it is, that there would be a president who would issue pardons for partisan reasons, for personal reasons. I can't believe they didn't take that into consideration as they wrote this provision. What would they be saying about some of the arguments we've heard from the other side?
Well, there were debates in the Philadelphia Convention as well as the Virginia Ratifying Convention about abuse of the pardon power. George Mason, who was invoked earlier, was very much worried about the president basically using the pardon to cover up his own crimes. And James Madison said the remedy in that case is impeachment. And I think that's probably the right answer. The pardon itself will remain valid, but the president can be convicted, removed from office, and apparently now under the prevailing wisdom, he can be convicted even after he leaves office. So there's still some teeth in Congress to punish them. But again, these are public acts, right? I don't like the secret pardons. That's not how this is supposed to work. It's a public act. We know what it is, and the president can be judged politically for his actions.
Thank you.
If we're going to do anything, why wouldn't there be something here that would say, look, one of the problems we have is that these pardons tend to occur on January 19th or 20th, right? They tend to occur right at the tail end when you're in the lame duck. You know, maybe you say that you could, maybe if you're going to do a structural limitation that might cut across on a bipartisan basis, maybe say pardons have to be finished prior to elections of the president's, term or something along those lines. I guess what I'm saying is if you're going to have a reform, wouldn't it be better to have a structural reform like that than something that gets into statutory bases with respect to family members? Are we going to say that John Kennedy couldn't have pardoned Bobby Kennedy if there was something that he felt was important to pardon just because his brother happened to be the attorney general? I don't think that's a good path to go down, in my view. Professor Blackman, do you have any thoughts on that?
Thank you. I actually did some research, and there were many proposed amendments. Representative Barney Frank of Massachusetts proposed an amendment in 2001 that did exactly what you suggested. It would have banned pardons from October through January 21st of any election year. So basically, before the election until after the inauguration, no pardons can be issued. As far as I know, no action was taken on that amendment, but that's almost exactly what you said, sir.
Representative Fischbach, you're recognized next.
Well, thank you very, very much. I appreciate that. And I'm coming to you from the beautiful state of Minnesota, where we are below zero here, but I am warm inside. So, but I appreciate the opportunity to just take a couple of minutes. And Mr. Johnson and Mr. McClintock, really covered some of the things that I wanted to ask, but I thought that I might just take the opportunity to offer Professor Blackman a few minutes just to expand on that issue of legislative involvement in the presidential pardon issue. It's something that I'm interested in, and was wondering if he had additional comments.
Sure. Well, thank you so much, Representative. I appreciate the chance. I think I'm hearing some interference in the background. It's a little hard to speak. I think it's someone's not on mute. I think the role of Congress here, I think, is important. I think the role, though, should occur after the fact in terms of oversight. In the event that the president issues perhaps a pardon that Congress deems unjust or inappropriate, that's something Congress can investigate. What I would hesitate is to put limitations on whom the president can issue a pardon to and how that pardon can be issued. And I'll just use H.R. 4 as an example. I'll read from it. It says a pardon issued for a corrupt purpose shall be invalid. The amendment does not define what a corrupt purpose is. It leaves it vague. A lot of us here are attorneys, not all of us are. When Congress doesn't define a statute, that lets someone else define it. It can let federal prosecutors define the statute, and it can let courts define the statute, right? It lets courts define this language. And I think if Congress wants to actually prohibit some specific act, they need to do something more than say a corrupt purpose, because that's not something that's self-evident. That's not a term that everyone understands. Do you think of any term that we argue about in the courts, emolument, right? People argue about these things. So if this body wants to put an amendment to prohibit certain kinds of actions, they should spell them out. What does it mean to be corrupt? I think bribery is already prohibited. I think the Constitution says you can impeach for bribery, and OLC has said you can prosecute perhaps a former president for bribery. But there's a difference between bribery and corruption, right? And corruption is one of these catch-all provisions. I think that's what Chairman Cohen said, a catch-all provision that can sweep in a lot of conduct that is perhaps unpopular, but I don't think fits within the traditional conception of an illegal offense.
Congressman to be recognized as someone who played in the NFL so long ago that he never played against Tom Brady. Representative Burgess Owens.
That's putting things in perspective. Thank you so much for that. Well, first of all, good morning, everyone, and my colleagues, subcommittee chair and ranking member. This is truly an honor to be with you. What I'm hoping to do is bring to this committee my long passion for criminal justice reform. I've had a mission for decades. I finally started Second Chance for Youth, working with at-risk kids coming out of the juvenile system and giving them a second chance. And I'm always pleased when Americans are given that second chance. Alice Johnson is a great example of that. A grandmother given a life sentence for her first offense. It took 22 years before someone heard her voice. And that was President Trump. Of course, President Obama for 8 years did not. I want to say something that CNN said about these pardons. CNN, the vast majority of pardons and commutations on Trump's list were doled out to individuals whose cases have been championed by criminal justice reform advocates, including people serving lengthy services in low-level offenses. I think we need to lean heavy on the wisdom of our forefathers, and they put a very high bar when it comes down to amendments. It needs to be passed by 2/3 of the House and Senate, and then go to the states, and three-quarters of the state legislators have to also pass. There's a reason why it's been done this way. It's purposely put in place not to be changed by passions in politics every 4 to 8 years, but by reason and time. But that's the difference in a democrat and democracy and republic. Our republic has lived for 200 years because of this reason over time. What's been the result of that? There's been over 10,000 attempts to change or amend our Constitution. It's only happened 27 times. So we, the people, are the ones that will make this happen. It's not done by a stroke of a pen. It will not be done by legislators every 4 or 8 years. It's done by we, the people. And even though this is very educational, I think these kind of conversations that we need to have so that we can understand this process and understand our Constitution. I can predict that this amendment will not be the 28th. So that being said, I do have a couple questions. Professor Blackman, what are the explicit limits in the Constitution did the founders place on the pardon power?
Thank you, Representative. Only two. The first is that the president can only pardon federal offenses, he can't pardon state offenses. And second, the president can pardon impeachments.
Okay. During the conventional constitutional convention, did the founders consider and reject legislative involvement in the president's pardon power? I want to clarify that one.
Yes, there were proposals of having actually the Congress involved, that the Congress would have to approve of pardons, and those were rejected. And Madison and others said that we really should put the power of the pardon in a single individual to ensure that there's speed and efficiency, and you can consider justice. As you know, when you have a lot of people in the Congress making decisions, they don't always agree on things. So in this case, a unitary executive does make some sense.
Okay. As I mentioned, this is something we go through almost every 4 to 8 years because it has become somewhat political. But can you kind of characterize President Obama's pardon of Chelsea Manning? It was something that I remember being a big deal for a while. And how does that compare with the majority of President Trump's pardons?
Well, I think the Manning pardon was quite controversial, precisely because WikiLeaks was involved and there was national security implications. But I think I'd make a bigger point. I think perhaps people on the one side of the aisle have a certain conception of the public good, and people on the other side of the aisle have a different conception of the public good. I don't think there's a single shared conception, and that's why we have elections. I think President Biden will probably look at different people to pardon than President Trump did, and that's what happens every 4 to 8 years. But I think your point's well taken, that different people think different pardons are controversial for very, very different reasons.
I just wanted to ask Professor Blackman to just kind of put a bow on all this. I mentioned in my opening that President Trump granted nearly 240 pardons and commutations. And, you know, we've heard a lot this morning about how he abused the pardon power, but according to the Pew Research Center, President Trump used, quote, the power less frequently than nearly every other president since the turn of the 20th century. Professor Blackman, I just wanted to ask you, would you agree that the grants of clemency and pardon and all that President Trump used was done by him, at least from his subjective viewpoint, in a way to rectify unjust sentences and prosecutions?
I think so. Maybe I'll focus on one in particular, Jack Johnson, who was a very famous boxer from the early 20th century, an African-American boxer. He was charged with violating the Mann Act, which, if you don't know what the Mann Act is, it's basically this very nebulous law that prohibited transporting a woman across state lines for immoral purposes. He had a mistress who happened to be white, and he was charged with basically having a relationship with a white woman, and he was sentenced to time in prison. This was almost 100 years ago, and this was a pardon that probably should have come some time ago. And I think it was one of the more commendable pardons that President Trump issued. I think it's worthwhile to stress here.
Mr. Hank Johnson has asked for a few minutes. I think he's the only person who has, and if with the permission of the committee and the indulgence, we'll recognize Mr. Johnson for our last round of questioning.
Thank you, Mr. Chairman. Professor Blackman, it would be fair to say that President Trump was rather stingy in his use of the pardon power compared to President Obama. Is that correct?
I think he should fear them, absolutely.
Yeah, in fact, Trump pardoned 143 and commuted 94 sentences. And Obama, in his 8 years, pardoned 212 and commuted 1,715 sentences. Would it be fair to say that President Trump commuting sentences showed more mercy than President Trump, who just simply let a bunch of folks off the hook, particularly in the wee hours of the morning on the night of January 19th? He issued, of his 237 total pardons and commutations, Trump commuted or pardoned more than 140 people in the wee hours of the morning, just 10 hours before his term ended, including Steve Bannon, a potential witness against him who was under indictment for defrauding Trump supporters in a build the wall scheme. Professor Blackman, would it be fair to say that it's best for the use of it's best for presidents to depend on the office of the pardon attorney rather than simply dispensing pardons and commutations out of their back pocket like President Trump did?
Well, I thank you for the question, Representative. The Constitution gives the president this power. The pardon attorney can make recommendations. I actually agree with Ms. Frederickson. It may make sense to have people who aren't in DOJ making these recommendations because very often DOJ is supporting the prosecutions. I think having someone
how many times did President Trump rely upon the office of pardon attorney before making any of his 237 commutations?
I don't know, but I guess the number is pretty small.